the Republican Party's unrelenting attacks on women's rights. The Supreme Court, the New York Times said, you'll recall the mifepristone case that went to the Supreme Court. The Supreme Court kicked it out for standing. They basically said, this group of doctors who don't prescribe mifepristone, the abortion pill, don't prescribe it, don't use it, don't have patients who use it, have no experience with it, because they're all opposed to it. This group of doctors has no standing to sue. They have not suffered an injury yet. They have an injury, a tort. Somebody has to be hurt before they can sue. And so when it came before the Supreme Court that they wanted mifepristone banned nationwide under the Comstock Act, which is what Matthew Kacsmaryk, the judge down in Amarillo, had been pitching, the court just said, "Yeah, we're not going to take this case. We're not going to make a decision." But even though they didn't make a decision, the Washington Post's headline was, "Supreme Court upholds broad access to key abortion pill mifepristone." They did no such thing. They didn't uphold broad access. They didn't decide the case. The New York Times, the headline, Supreme Court maintains, same thing. Supreme Court maintains broad access to abortion pill. Almost identical headlines, and they're both deceptive. Like, the Supreme Court finally got something right. Like, these justices aren't quite as crazy and right-wing as we thought they were. Yes, they are. They're worse than you thought. So, in fact, Justice Kavanaugh, in his unanimous opinion, he said, Article 3 of the Constitution confines the jurisdiction of federal courts to cases and controversies. As Justice Scalia memorably said, Article 3 requires a plaintiff to first ask a basic question, what's it to you? To sue in federal court, a plaintiff must show that he or she has suffered or likely will suffer an injury in fact. So, where do we go with this? Well, I can guarantee you, right now, the anti-abortion freaks, the anti-abortion movement, are looking for somebody who was harmed by mifepristone. Some woman who took mifepristone for an abortion and it didn't completely abort and she ended up in the ER. That does happen from time to time. Somebody who took mifepristone and had one of the wild, rare side effects. Some husband whose wife took mifepristone and aborted a baby without his permission, who feels that he was robbed of having a son or daughter. They're going to find somebody, and probably multiple somebodies, who have actual injuries, or what they would characterize as actual injuries. And they're going to bring this case to the Supreme Court again. And this time, which will be next year, the Supreme Court basically is, by my idea, my theory about why the Supreme Court punted on this thing is that they know that America is pissed at them. We're upset about, these right-wing decisions. Bump stocks, you can now make an AR-15 fire 800 bullets a minute. People aren't happy about that. The Dobbs decision outlawing abortion, people aren't happy about that. There's been a number of these right-wing decisions that people are just grossed out by. So the conservatives on the court, I think if they had banned mifepristone, which they clearly want to do, and this worked its way through, it started with Matthew Kacsmaryk, and then it went through the Fifth Circuit, where James Ho, the judge who wrote the torture memo for George W. Bush to legalize torturing Afghan and Iraqi prisoners of war. His wife actually is a paid speaker, lecturer on behalf of an anti-abortion group. I believe it's the Susan B. Anthony Fund. I could be wrong. And yet he didn't recuse himself. He ruled, yes, mifepristone should be illegal nationwide. Pass it on to the Supreme Court. So, in all probability, it'll follow the same route. There's going to be a case where they've got somebody who's got an injury, some sort of injury, and they're going to take that case to Matthew Kacsmaryk in Amarillo, Texas, or some other judge very much like him, maybe Eileen Cannon down in Florida, who knows. And from there, it'll go to the Fifth Circuit. If it's in the South, if it's in the Deep South, that's the Fifth Circuit. And from the Fifth Circuit, it'll go to the Supreme Court. And the Supreme Court will finally have an opportunity, or at least the 6 right-wing Catholics on the Supreme Court will finally have an opportunity to outlaw the abortion pill. And I'm telling you, this is coming. This is not a small thing. They are, once they can get standing. And the biggest point here that was virtually unmentioned, I read both the Times story and the Washington Post story, and the Comstock Act got, as I recall, a 1-sentence reference in one of those 2 stories. The Comstock Act, Anthony Comstock, we've talked about this before, he was this weird guy in the late 1800s, early 1900s, who thought that, sex was a terrible thing, and masturbation would make you crazy, and he delighted, he was the New York Postmaster General, but he delighted in shutting down burlesque shows in New York and arresting women for, public indecency. His legislation makes it a federal crime to send anything through the mail that can be used to cause an abortion. That bill, that law, which was passed in the 1890s, is still on the books. Now, the Biden administration thought that the Supreme Court had, nullified parts of it back in 1918, I think it was. But, the right-wingers are arguing that it is not nullified. It's still in effect. And Erin Hawley, the wife of Senator Josh Hawley, the person who argued this before the Supreme Court and before the Fifth Circuit and before Kaczmarek, Erin Hawley is gung-ho to revive the Comstock Act. So keep an eye on this. This is another one of those cases where the Supreme Court is pulling their punches right now because they don't want to piss off, they don't want to lose any more Republican votes before the election. But after the election, all bets are off.
This is the Thom Hartmann Program.
I'll be right back on the other side of this break. Stay with us.